We're delighted to have you all back for our second panel. We're ticking right away here, and I have the honor of introducing our next moderator, Justice Charles T. Canady. Justice Canady first joined the bench in 2002 on the Second District Court of Appeal, and then on August 28th, 2008, he was appointed to the Florida Supreme Court. He served as Chief Justice of the Florida Supreme Court 3 times now, most immediately ending, I think, just in 2020, and has returned as Justice. He received his BA from Haverford College in 1976 and his JD from Yale Law School. And before joining the bench, he was a member of the House, the Florida House of Representatives, as well as the U.S. House of Representatives. And in addition to that, he, during the time in the U.S. House, was always a member of the Judiciary Committee, and at one point, also the chairman of the House Judiciary Subcommittee on the Constitution. So it is an honor to have Justice Canady here to lead us through our second panel, and I'll turn it over to you. Thank you.
Thank you very much. I appreciate the kind introduction. I'm delighted to be here today to moderate this panel. We have a very distinguished panel. Unfortunately, one of the panelists who was scheduled to be with us, Professor Wolf Townsend of Georgetown, was unable to, as it turned out, to be here. He was providentially hindered. But the 3 remaining panelists are people with outstanding experience in the subject of class actions, which is what the focus of this panel will be on. Now, on the first panel, we heard some things about class actions, and I think that the fact that that was a focus of the first panel, the kind of general panel, shows the significance of class actions in the arena of civil issues. And so, but in this panel, we're going to focus specifically, the panelists are going to focus specifically on class actions. The first person we'll hear from is Christopher Appel, who is currently with Shook, Hardy, and Bacon in Washington, D.C. And Christopher is the author of more than 30 law review articles. We were talking about that beforehand, and I said, well, who else here among us could even claim to having read 30 law review articles, much less having authored them? So Chris is a scholar and is an expert in this area from his prolific body of work, as we can see. The second person who will present will be Basheer Ghorayeb, who is managing counsel at Toyota Motors North America. He came to Toyota after a 20-year career as a trial lawyer, and kind of moved from that arena into the corporate arena, and so he brings that perspective to the panel today. The third panelist is Daniel Karon, who is lead counsel for several notable class actions. He has his own firm, Karon, L.L.P. in Cleveland, and he has been the chair of the ABA National Institute on Class Actions. And I think, as you can see from the introductions, we have a panel here with extensive experience in this very interesting and very complicated area of the law. So with that, I will turn it over to Chris.
Sure. Thank you again for having me and for all of you coming out here. I'll try to make it as uncomplicated as I can. There are a lot of issues in the area of class action reform. I'm just going to focus my remarks on 2 topics that I find particularly important. First is no injury class actions. You probably heard that, come across that in some area, just that phrase. What they are, why are they problematic, and then second, to discuss the superiority requirement of the class action device, which is an issue that can be implicated in no injury class actions, but is really more of a broader issue consideration when discussing class actions. And I think it's always helpful to begin with a disclaimer of my background biases, kind of to get a sense of where I'm coming from and how I view these topics. I'm not an attorney who primary practice involves litigating class actions. My public policy law practice, as was alluded to in Washington, D.C., focuses on identifying and responding to areas of abuse throughout the civil justice system, and class actions just happen to represent one such area where I work. So I tend to enter the conversation not when there's abuse in a particular case, or arguable alleged abuse in a particular case, or unfairness. I really enter the conversation when there's something that impacts a broader swath of cases or an entire industry or industries. Really, the best analogy is probably like a macroeconomist versus a microeconomist. And so when I look at the world of class actions, the biggest problem, in my view, continues to be that so many class actions are driven not by people actually sustaining any harm, but rather by creative lawyers who are actively seeking out plaintiffs to bring litigation. And that dynamic has always struck me as bizarre and frankly prone to abuse. And you see it in a lot of different types of class actions where consumers get an almost meaningless coupon that few redeem, some other token form of recovery, while the attorney collects a significant payday. You have securities class actions where winning the lawsuit actually can leave the class members in a worse position, or at least one with no tangible benefit. As some of you may have seen a number of years ago, that even an analysis by the Consumer Financial Protection Bureau, which is not exactly a pro-industry government entity, reported an average claims weight of just 4% in consumer class actions, and that figure is a lot higher in studies that have been conducted since. So no injury class actions really represent another step, evolution maybe, in the search to generate litigation as opposed to responding to claimants with a clear existing injury. And there are a number of different variants of different types of no injury class actions, but they often share some common characteristics. First, the claims often implicate unmanifested product defects. So this might involve a claim that a product has malfunctioned for the named plaintiff, but it only has the potential to malfunction for all the other class members, but it's not actually caused any problem for virtually all of the class members or most of the class members. So the action proposes to essentially bootstrap the claims of the individual with an injury, with a genuine injury, with those without an injury. One example that garnered a lot of headlines a number of years ago was a small number of purchasers of washing machines experienced an unpleasant odor due to an alleged design defect, and brought a class action on behalf of all washing machine owners, even though 99% of them never experienced any issue and never will. Sometimes you have a class action that only involves a theoretical injury for all of the class members. And I imagine we'll be discussing that as this goes along. Another commonality of no injury class actions, it's a liability theory predicated on alleged overpayment or some loss of a benefit of the bargain. The idea here is that because of a product's potential to develop an issue, it is worth less than what a consumer paid for it. So all of the purchasers should get to recover economic damages, perhaps through a partial refund, a coupon, some other mechanism. One example I'd find particularly jarring is that purchasers of airline tickets who arrived safely at their destination brought a class action against Boeing and Southwest seeking ticket refunds based on an alleged design defect in Boeing's 737 MAX 8. And these are consumers who realize their desired travel plans without sustaining injury, yet still want compensation, even though there's no possibility of an injury because their travel is over. Now, on the surface, the idea of addressing alleged overpayment might sound very sensible. No one likes overpaying for things, but this quickly breaks down under scrutiny, particularly when brought as a class action. And first, even ignoring that no one has actually suffered a concrete injury, which is a pretty big thing to overlook because of the bedrock principle of liability law, but even overlooking that, the general notion of consumers paying too much is a highly individualized assessment that is unsuited for class treatment. There will undoubtedly be some class members who, if informed of all of the risks that are complained of, would have purchased the product at the same whatever product we're talking about, at the same price, so they did not lose any benefit of the bargain under any theory. Others might pay different amounts based on their personal preferences. It's also important to bear in mind that not everyone pays the same price for some bigger ticket item products. To get around this, though, the lawyers have sought to have experts develop composites or formulas. You've probably heard about this in some capacity, basically computing a theoretical economic injury for a product that many, if not most users, were completely satisfied with and never experienced an issue. And this is also, it also doesn't reflect many, if not most, proposed class members' actual or purchase experience. And in my one man's opinion, this is the opposite of what a class action comprised of individuals who have suffered the same type and scope of injury is supposed to be. Another basic problem with no-injury class actions is that they perpetuate a legal fiction, that consumers have no other viable remedies. We have entire fields of warranty law, consumer protection law that address harm to an individual caused by product misrepresentations. We have a regulatory oversight of many industries that has the power to address widespread complaints about potential product risks or even overpayment by consumers. The CPSC, NHTSA, various other government entities can recall products and require manufacturers to take certain actions. I'm sure Basheer can speak to that better than anybody. The FDA can regulate food labeling, which has been a source of many no-injury class actions. You may have come across the litigation over the phrase all natural and variants of that. And finally, we have an entire field of products liability that addresses when a defective product actually causes harm. And the idea of a consumer's benefit of the bargain incorporates the existence of these other areas of law that safeguard consumers. So part of the bargain at the point of sale is that these protections can and will be triggered if needed. So it doesn't follow that class actions that effectively supplant or duplicate these other laws should be permitted, especially under a benefit of the bargain theory. And I think the fact that the lawyers bringing the class actions are often the primary beneficiaries of them helps illustrate that weak foundation. And all of this relates to the other topic I wanted to discuss, which is the superiority of the class action device. I think it often gets lost that class actions are meant for exceptional circumstances. It's not every controversy impacting a significant number of people, and certainly not every time a significant number of people feel they paid too much for something. Still, that's unfortunately the direction things have been headed. I saw a survey that last year that businesses spent a record $3.4 billion defending class actions, which was a double-digit jump over the previous year. And that was in the middle of a pandemic, so when a lot of the courts were closed. So as everyone here has come across, the Federal Rule of Civil Procedure 23B3 and many comparable state laws require courts considering class certification to determine whether the class action is superior to other available methods for fairly and efficiently adjudicating the controversy. And one problem with Rule 23 in state laws is that it doesn't explicitly require courts to consider non-litigation remedies that counsel against having a class action. And I think we'll get into that during the discussion, but to the extent people read their reading material, this is a shameless plug also for the organization Lawyers for Civil Justice that recently petitioned the Federal Advisory Committee on Civil Rules to amend Rule 23 to address this issue. I personally raise it here because I think courts should consider a manufacturer's voluntary voluntary product recall, or some sort of extended warranty or refund program, free software patch, or other remedial mechanism when deciding whether or not a class action is appropriate. And there are plenty of issues we can discuss about ways that judges can take action to kind of address class action abuse, which we can get into, but I've spoken enough, so I will let others speak now.
So can I ask by a show of hands, how many of you when you're in your car use a button to start the engine? All right. How many of you still have the key that you put in the ignition and twist? All right. And how many of you who have the push button wish you could go back to the key that you could twist? One guy, it's class action plaintiff right there. So we introduced that technology, the smart key, in 2004. And people loved it. And we know they love it because Toyota, if you bought a Toyota, you'll get these surveys after you buy the car, 30-day survey, 60-day survey, 90-day survey. And we'll even have an open response, tell us about your car. Because we want to know there's something wrong with it, we want to be able to fix it. What we were getting was, of all the things that are on the car, they were talking about the key fob and the smart key. I love that I don't have to take the key fob out of my purse. I love the convenience of the push button. And so is this a corporate success story? We've met our client's need? No, I think it's a story of a legal failure because we got sued. And the lawsuit, the class action was, this is a new technology. And there's a risk now that people are going to make mistakes. They're going to get out of the car and they're not going to push the button. And they're going to get out and the car's going to still be running. And so there could be carbon monoxide poisoning. There could be theft. Someone could get in the car and take it. There could be a rollaway, because what if they didn't put it in park before they get out? Now the car could roll away and someone could get hurt. Now, the class action was filed in state court in 2010 in California. And keep in mind what the claim is here. It's not that somebody got hurt. It's not that my car got stolen. Those would be actual injuries. You probably have a products liability suit, a negligence lawsuit, if that happened. They're talking about a risk. You've put me at a risk of these bad things happening. And the legal theory really was a failure to disclose. When you sold me this car, you didn't tell me that I was being subjected to this increased risk. It's an unfair trade practice. And I've overpaid for this vehicle. If I had known that risk, I wouldn't have paid what I paid for the vehicle. And that case makes it through the motion to dismiss, the equivalent in California, makes it through summary judgment. We're into discovery, and the case is pending years. And now it's 2015. The state court class action has been there for 5 years. And the same theory is brought in federal court. 5 federal class actions, consolidated, federal judge in California dismisses the case in less than a year and says, this isn't what we need a class action for. Nobody's hurt. You're suing over a theoretical risk. You're dismissed. And in state court, we're still in litigation. And meanwhile, in discovery, we have experts from both sides scouring, is there a trend of increased poisoning, of rollaways, of thefts? There isn't. But the courts can kick the can down the road. We don't want to get in the merits yet. That's something that we'll do later in the case. And finally, in 2017, the class is going to be certified. Court has a hearing. Should we have a class action? The court starts getting troubled. Wait a minute. If the theory is that people are at a greater propensity of making a mistake with their car, am I going to now need to go to each individual plaintiff in the class and go, how is your risk increased? How do you handle your keys and turning off the car? Do you have a garage so that you can have carbon monoxide poisoning? Or do you park your car outside? And that's what troubled the court in the end and led the court not to certify the class, not the other issues in the case. And so I think some people hear that case, especially lawyers, and go, I don't know what the problem is, Basheer. That's the legal system coming to the right result. And to me, it's really hard, though, as an in-house lawyer. I practiced for 20 years, an outside lawyer, and I thought, I really want to get closer to the client. I want to see if I can advise on issues before they ever become lawsuits. I want to really explain our legal system to the engineers, to the business. And they turn on me and they tell me cases like this, and they say, well, explain to me what's going on. Same case in federal court. We're not going to waste the court's time with class action when there's no injury. State court, let's have 7 years of litigation. And the engineers are bothered because they're the ones who are having to go find the documents. They're the ones who signed the affidavit for the class certification motion trying to explain the technology. And they tell me, we'd like to be pushing out new technologies. We'd like to be looking in the field for problems and fixing problems that could actually hurt people. We don't want to be in this litigation machine when there's no benefit to anybody. And so that's become really hard for me to explain and justify what we're trying to do. Very similar to that is the post-recall litigation, recall follow-on litigation. What happens there is we announce a recall for vehicles, and you'll get a class action. It's almost like in the old days when the stock price would drop, there'd be immediately some kind of securities litigation. Now there's plaintiffs, attorneys, they see that there's a recall, you file a class action. And the theory often is, there's something wrong with the car, you didn't disclose it to me when you sold it to me, I wouldn't have paid the same amount of money for that vehicle. So it's not that I have the issue that's in the recall, it's that I was subjected to the risk of the recall. And a lot of you are thinking, well, Basheer, that's apples and oranges. I was with you maybe on the push button. That doesn't sound like the best use of my court's time. But a recall, aren't you admitting that there's something wrong with your car? But you got to think about what a recall is. Let's say there's a factory and it's going to produce 1,000 vehicles today, and there's a machine that's failing on the line. And every fourth vehicle is just not tightening one bolt tight enough. And so at the end of the day, 250 vehicles, 1 out of 4, has a bolt that might not be tight enough. Now, does that mean there's something wrong with the car? Well, there's a risk that depending on how you drive that vehicle, how long you own it, the road that you're on, that bolt could come loose and you would have a problem with your car. But you could have it for 10, 15 years and never manifest itself. And that's what happens when you get the recall notice. We're going to go recall those 1,000 cars. We're not going to take that risk. And we're going to ask you to bring it into the dealer. And the dealer's going to look at the bolts on your car. And you might be one of those 250 vehicles that came out of the factory that day. And they'll tighten that bolt up for you. So when you get a recall notice, it doesn't necessarily mean there's something wrong with your car, that you were going to have that risk manifest itself while you own the product. But there's enough of a risk that we're either required to by statute, or sometimes these are voluntary programs. It may not be a recall, it may be a customer satisfaction program, where we don't want to take the risk and we want to fix it for you. So to me, when a class action is filed, and it often is after these recalls, you're in the same situation with the push button. We're doing something to help our customers. Nobody's hurt. In fact, if you think about the recall, I've already pushed out their remedy. What are you going to get out of 7 years of litigation I haven't already given you? I've already given you a remedy. Come to the dealer, no cost, I'm going to fix it for you. And so it becomes very difficult for me to explain, again, to my clients, what do we want them to do as a legal system? And especially, remember, I have clients from Japan. I have other countries. I'm trying to explain our legal system to folks from other cultures. And I think it's appropriate where the Law and Economics Center, we've got to think of it with our economics hat on. What are the behaviors in society that I want to incentivize, and what are the ones I want to penalize? And so do I want people pushing out technology that people like that's going to make their life easier? Yes, so I should be incentivizing that, not penalizing it. Do I want companies to take responsibility and fix their vehicles and issue a remedy and publicly announce it? Then we should incentivize it and not make it something that we penalize. And do we want class actions where there's just theoretical injuries, or the remedies already available out there in the market? You could go to the dealer today rather than wait 7, 8 years for the litigation to end. Do we want to incentivize that kind of litigation for no real tangible purpose for the customer, or do we want to disincentivize it?
Well, I was a speech and rhetoric major in undergrad, so let me ask if anybody knows the first rule of public speaking. I've never had anybody answer this. I ask it every year, every time I speak. It's to know your audience. And I don't know if it's a function of my having gotten here a little bit late, but I don't know what your all's constitution is. I mean, let me just ask, how many of y'all are state court judges? Oh, whoa, there you go. Federal judges? Private practice on the defense side? 1, 2, 3, 4. Okay. And how about plaintiffs' lawyers? Okay. All right, fine. Well, I've done mostly plaintiffs' work for 30 years, and you're not going to hear me defending a lot of what these guys just said, in particular, say the Toyota ignition switch litigation. I mean, there's nobody at Toyota who's black-hearted and greedy enough to want to screw people over pennies at a time to get rich off a push button. It's a great invention, and I have one too. I have 2 of them. But, and I, in a Toyota, no less. I told you the 4Runner, great car. Got 160,000 miles out of it. But, you know, you take a look at cases like your Starbucks iced coffee, your Subway footlong, and it makes it tough to defend what I do, excuse me, for most of my practice, because they're bullshit cases. I mean, it's kind of like obscenity, right? We know what the standard for obscenity is? There you go. And we all do. Even the guys bringing these cases know that they're stupid cases, but they're looking to make a dime. And that leaves somebody like me defending the practice, whether it be here or with my in-laws or at a party or who knows what. But it's a really crippling, disabling, uncomfortable, unsettling, not very happy state of play when you've got to defend your basically your right to practice all the time because the deck's stacked against you. Now that said, let's understand the playing field. not all cases are stupid cases. I mean, Chris is talking about no injury or economic loss class actions. We're talking a bit about some bad products cases, but a lot of my cases involve big companies who are class representatives or class members. Say price fixing cases where companies want to get their money back for having overpaid for price fixed computer screens or beef or tuna or chicken or whatever other commodity product. Hang on, I had a thought and it just went away. Good cases. Give me 2 seconds. Okay, anyway, so there are a lot of good cases out there. And the case, it came back to me, got it. The cases I like to talk about are the ones that to me are meaningful, important, and essential to people to make their lives better and happier and more productive. So for instance, I'm counsel in that Ohio State sex abuse case. Does anybody know about that? You guys do, yep. That's where this doctor went rogue at Ohio State University back in the 70s, 80s, molested upwards of 3,000 student athletes, and the school covered it up, and everybody knows it, including the school. They commissioned a study, and that's what the study resolved, and the school owned the indiscretion, but they kicked out the case. Not okay. If I want to talk about a case I'm working on, I talk about that one. I had a case against Lifetime Fitness. Is Lifetime Fitness out here? No? Okay, it's a big fitness chain. They were making group fitness instructors, yoga, Pilates, aerobics, and so on, show up 15 minutes early to set up, work for an hour, of teaching time, stick around 15 minutes afterward to clean up, yet they were only paying them for the hour of teaching time despite having promised to pay them by the hour, not by the class, not a piece rate as it's called in the law, but by the hour, thereby chinching them out of 30 minutes of every time teaching, and it added up to a lot. And these are a lot of young people who need the money, who are trying to just get by with teaching in addition to school and other obligations, and we get them a bunch of money back. I like talking about that. I mean, you rankled about those stories, are you? Those are good stories. Okay. So there are a lot of good cases out there, but you can't deny that it's the bad apple that ruins the whole bunch, or a lot of bad apples, really. And that's why after about 30 years of doing plaintiff's work, I wanted to do something proactive to help stem this tide before class actions died, because courtroom doors closing, access to justice withering isn't just bad for good class actions, it's bad for well-behaving companies who thereby would lose market share and sales and profits to unpoliced cheaters who wouldn't have any laws holding them back from doing wrong things. You all are doing it right. Somebody else could do it wrong and eat your lunch, and that's not okay. So we don't want to kill the device, we want to kill the bad cases. So I got to thinking, how can I be proactive in that effort? What can I do as one guy? What model or effort might allow me to make a difference? So I started doing defense work, but not in the normal, ordinary sense. In my capacity as running the ABA National Institute on Class Actions for 13 years, I just retired from it. I'd had enough. It was like planning my bar mitzvah every year. I didn't need it. My wife would be the first to tell you nobody needs to hear anything more out of me, so I stepped down. But I can't shut up anyway, so I'm showing up in a couple weeks, and I'm teaching a gig there just the same. But anyway, I met a lot of folks, and still meet a lot of folks, and met Basheer, and continue to do it the more I get out and deliver my message. And the message is one of responsibility and accountability, and really taking a stand for what's right. And I've met a lot of in-house folks. And they, one in particular says to me after one of these class action institutes, or during it, I should say, he said, listen, I really dig your message. I mean, it's really responsible and sensible. You sound like you're kind of selling it right down the middle, which I do, and you're hearing it now. Could you maybe tell our folks in-house how we can brace for, defend against, account for these bad consumer class actions that keep coming and coming and coming at us in waves? Always out of California, right, with the CLRA letter, which is the notice letter before they end up suing you. I said, you know what? If you get a CLRA letter out of California, or a Rule 93A letter out of Massachusetts, same kind of thing, Basheer, right? If you get it, you call Chris. And the last person, plaintiff's counsel, schlocky plaintiff's counsel, some strip mall lawyer in Tarzana is going to talk to is Chris. And the second to last person he's going to talk to is Basheer. But I said, you know what? if they want to talk to somebody they know, whose brand they understand and trust, because I'm in their same space, and I'm going to sell it to them, give it to them straight, let me get in there and have a conversation. Let me tell them why it's not just that it's a bad idea, but why it's a bad idea, and what consequences it'll have, not just for him and his practice, but for the practice in general, and how that's going to spill over onto him reputationally. Let me then give him discovery, free, cheap, with an explanation from a trustworthy voice, where I can explain why this isn't something you want to do, man. It's a bad idea. Trust me, I can't lie to you. If I lie to you, my reputation is shot, and I'm done. I never lie about anything, and you shouldn't even have to say you don't. You just don't. And I've not had one engagement with a big company where I've not talked some plaintiff's lawyer off the ledge and had him go away for not a lot of money. Sorry about your practice, Chris. I took your business, and it's not going to be some long thing through class cert or summary judgment. But you know what? Basheer doesn't care. He wants it out. He wants it gone. And I'm happy to do it because it helps the system, the process, everybody involved. And that's what I'm interested in doing, is preserving what we do, not just for victims on both sides, well, really on the plaintiff side, but to get victims on the defense side out of the game as quickly as possible, so as to maintain an opportunity for right case, proper, suitable, appropriate, ethically sued cases to have their day in court. And to have judges look at these cases and respect them, free from all the clatter that infects often otherwise good cases. So, are there a lot of textual issues that blend into this, of course? Am I having a robust Rule 23 discussion with somebody at the front end about, say, superiority, like Chris said, for instance? It's a toothpaste brand. And, it doesn't whiten as advertised. A lot of predominance issues there. Does it, doesn't it, for whom, how often do you use it? Do you use it right? User error? How about the advertisement on the box that says, you have a problem, give us a call. We'll give you your money back. We'll give you your money back times 2. We want to make it right because Colgate, P&G, whomever wants to do what's right by people. There are no black hearts working in these companies. Maybe Volkswagen. I don't know. But otherwise, there probably isn't. Not that I've seen. And they want to do right by folks. Now, you could get into, as a function of Rule 23A, is a self-help type remedy a superior method of adjudicating the dispute? Well, plaintiff's lawyers would say no, because it's not an adjudicative process. It's not done in the courts. It's done outside the courts. And then you get into the case law. And once you're in the case law, you're in the crap. And then you're spending money, and that's not where Basheer wants to be, with whomever. So I have that discussion too. You got to have some chops to pull this off. Often the folks who sue these cases don't have the chops, which is why they're stuck suing these cases rather than real ones, rather than a price-fixing case that matters, rather than a securities case that matters against Enron or WorldCom or whomever. They sue a nickel and dime, plaintiff's consumer case, and makes the whole system, it sullies and dirties and messes up the whole system. It gets on the news. It's not good for anybody. Maybe it's good for defense counsel, but it's respectfully, but you know what I mean. But it's really not good for anybody because you don't want those out there. That's not what Rule 23 is intended to address, and it's not something that I want to endorse. So I've tried, in fact, what I did was I even developed a brand around this, this kind of defense-minded practice. And here's my little brochure. It says, Karon LLC, Plaintiff's Counsel for Defendants. I thought that was clever. Because they need a mind in the, on their side who knows from the other sides, from the, bottom feeder plaintiff's lawyers, concerns, aptitudes, limitations, fears, politics, reputation, all this stuff. Often, I know these guys. So that's where I am now in this space. It's not just straight ahead doing plaintiff's work and putting my head down and not thinking twice. It's thinking really hard, but a lot of these themes and concepts and writing a lot about them so as to get a good message out there and talking about them to folks like you, to let y'all understand that it's really not most of it. It's some of us, and it's some of us that the rest of us don't much care for. And I, for one, am trying to do my best to see if I can't right the ship and let class actions do their proper job.
Well, it seems like I should let you write this off as business development by asking you for this brochure here.
You got it. And I have more.
Well, this kind of reminds me just of the first panel where they were scratching their head of why Justice Thomas and Justice Kagan could ally on some issues. And I am seeing it on some of these class actions that Chris was mentioning, where we have experienced class action counsel come to us and they say, look, there's obviously a need for class actions, for consumer class actions for the right case. And we're worried that these other cases are going to create precedent and new rule reforms that could affect the cases we want to preserve. And so I have seen, I had a case where an experienced plaintiff's counsel tried to talk out their partners that they normally partner on a case, saying, you don't want to bring this case. And the problem we have is for all these good plaintiffs' attorneys who care about preserving class actions, there's other folks who maybe they can't get the better class actions because those will go to Dan. And so they're left with the ones that are problematic, that the more experienced plaintiffs' attorneys aren't going to take. And there's nobody minding the store because the name plaintiff, I mean, in the push button case, it was really funny because when depositions started and you started asking these plaintiffs, oh, I love my push button. We're like, we could deactivate it for you. Oh, no, please, no. They had to drop that one because he just went on so much about how much he loved it. He just lent his name to the case, plaintiff's attorney buddy of his, and he didn't really have a problem. But the issue is, can we really trust for self-policing? So a lot of this is happening before it hits your courts. We're in discussions. We do this, we call a free discovery, confidential discovery. Look, let me just give you a preview. People aren't complaining about this. People aren't being injured. And sometimes it succeeds. But let's say I get 6 class actions. Maybe I talk 2 out of the 6. Now I still have 4 class actions on this technology that's going to get consolidated that I got to proceed against. So I still need something else to bring these under control, to give predictability to the plaintiff's bar and the defense bar. So when we have these discussions, I can tell them this is how it's going to go. But right now, it's I'm going to roll the dice and see if I can get by for 7 years.
But there's nothing worse than bringing a bad case. Because, and there's nothing worse than getting past 12b-6 on a bad case. Because talk about, winning enough rope to hang yourself with. Because then you're, stuck in discovery for 3, 4, 5 years, and you get into summary judgment and Daubert, and what if you get past that? And then what if you get flipped? Or what if you go to trial, get flipped? What if you settle it and an objector shows up because it's a stupid settlement? And then it gets gutted or, the settlement gets flipped on appeal. There's nothing more disabling than to have a case that you wish you hadn't brought. And you got to be honest enough with yourself to know that. I think these folks tend to be. I'm always apt to say, as are my colleagues, often the best case is the one you don't bring, because, or I say run away from, because you got to be able to go through this analysis from a mile away and know that it's just going to really ravage you, and it's just for the wrong reasons. It's not just about making money. I once said to a former partner of mine, I said, if I wanted to make money, I could do pretty much anything. But if I want to make a difference, that's why I became a lawyer. And he said, what are you talking about? I said, you know what, I put that on the list, and that was one of the reasons I quit my own firm. But you got to do the right thing for the right reasons. And there's no shame or harm in making a buck. Everyone here is making money. When plaintiff's lawyers make money, it's making out. That's not okay. I've written an essay on that too. And we're all just trying to make a living by doing what's right, what we believe in, but we have to be honest with ourselves. And most plaintiff's lawyers are. Those who aren't are why we're talking about this.
Yeah, I'll just chime in. Actually, Dan, when Dan was talking, we actually have a similarity in our jobs. I have a small little practice group in a big litigation firm, and actually my job is essentially to take business away from my firm. So, because as I mentioned earlier, I kind of do the macro level stuff. So, if you're successful on the macro level, that means less litigation for the rest of the firm. But they probably, hopefully this isn't video recorded or anything. The other point I just wanted to make is, and it was, Basheer touched on a little bit, is that even if you're successful in talking that plaintiff's lawyer off the ledge and saying, don't bring this case, which is great. I mean, that's helpful to rooting out bad apples. The problem, and one of the problems in my view, is that someone else is just going to step up and take their place. Like you can be successful in rooting out one, but they just might mention it to one of their buddies, and that buddy runs with it. What you need is a system where these BS, to use your term, class actions are.
I gave you the plaintiff's version.
Yeah. Are not financially viable. You need to have an incentive system set up where you can't file one of these cases, and even if you don't think it's the strongest, even if you don't think it's a good case, you can still use it and leverage some sort of settlement for some nuisance value of litigating the case, which in a class action context is big because the stakes are so high. So you really just need to have a system where they're disallowed in the first instance, and you funnel in the good class action. So,
Wow, have you figured that system out?
no, that's why,
Okay.
again, so yeah, I can get into one of my personal pet projects is, I don't know if anyone's going to jump on this, but one way to change the incentive structure for members of the plaintiff's bar is you tie fees in a successful class action to the recovery rates of the class members. Basically, so if you had a system where and again, this is a little bit theoretical because it's kind of hard to do from a rulemaking approach or some sort of whatever implementation system there would be. But in a perfect world, I would find a mechanism to tie if 3% of consumers are recovering or claiming their coupon, the plaintiff's lawyer bringing the case doesn't get credit for the purported class of 400,000 people. They get credit for the 3% who redeemed their coupon, and their fee is tied to that. When you put skin in the game like that, it actually does force people essentially to bring the viable cases and avoid the non-viable cases.
Well, that's CAFA, though. I mean, that's already in there in terms of the redemption rate and fees. I think you mean like notice.
Well, I mean, for state-
maybe completing, oh, okay.
Yeah, I mean, for another issue that we
How
could
about notice?
probably
How about-
discuss is how all the class actions are eventually going to move to a state level. But
Right. But, you make it, I mean, that's an interesting point because, claims rates are so low, and we struggle so hard to keep claims up. I've got a case settling now where it's a no-claims settlement, and we pushed really hard for that because I have 2 settlements where there are no-claim settlements. People are just getting their pro rata shares because I don't want to rely on people seeing a notice, wondering what it is, wondering whether it's fraudulent, whether they're getting scammed again. It's just, and then the claims rates are down, and we feel terrible because there's all this money left over. You could pray it, which is still not out of vogue entirely, especially after that cert denial in what the heck case was it? I think I have it right, where pray isn't anywhere near dead, or on the life support some folks would ascribe it to be on, but or claim it's on. But there's a lot of bad attitude amongst folks where if people don't claim what you give them, should the lawyers get paid for having given them the opportunity? To which the plaintiff's lawyers say, well, you can lead a horse to water, but you can't make him drink or her drink, and how much can we be expected to do? And I know where I am in the Sixth Circuit, the jurisprudence allows plaintiffs to take a fee on what they've amassed for folks, never mind how tepid the notice or the claims, the take rate might end up being. And we don't take any joy or comfort in that. We're not doing it to solely get paid. Like I said, you get paid doing anything. I could have been, I could sell something. I could be an investment banker, whatever. But you want to help folks and get them back what they deserve. And if they don't go there, which often folks don't, because how often do we fill out claims, especially if they're low-value claims? Like, oh, screw it. It's not even worth it, right? I do, because I know it's behind the effort. A lot of folks don't. And that's a real problem, and we're struggling with that all the time. In fact, in a settlement I've got, it's been finally approved, and we're going through claims, and we just redid the math, and there are a lot of really low-value claims. We're like, ugh, we can't justify, we can't spend money mailing checks for a quarter to people. That's ridiculous. So we're going back into court and asking to pray all this money that would otherwise go unappreciated or even unclaimed and put it to a charity. And that's like a good thing. I feel really good about that. I'll bet you it goes through. There's no reason it ought not go through, but it's certainly more productive and effective and useful than sending somebody a 25-cent check. That's not only useless, it's insulting. And we don't want to do that. That's not the point behind what I did for 8 years in this case, is to insult people, is to help people.
All right. Well, thank you all. Let's thank the panelists for their presentation. And I have a question I'd like to start off with. As you saw from the hands that were raised, most of us are state court judges. And I think it might be helpful if you would just comment on the kind of the state versus federal landscape and what goes to federal court. And my sense is that, like most things, but my sense might be wrong, but just based on my perspective as a judge from my particular state. Mm-hmm. But what goes to state court? What goes to federal court? Why? What states? Where's the real action? We've had some indication of that already. But if you could kind of discuss that federal-state landscape issue.
Chris, do you want to go first?
You can
All of
you.
You litigate these.
Okay, fine. Well, we give a lot of thought to where to sue a case. If it's subject to the Class Action Fairness Act, minimal diversity and amount in controversy over $5 million, whatever that means, then we're going to be in federal court. So often, any meaningful case is in federal court, unless that is, it's a statutory damages claim, which is subject to spokio and TransUnion, and then you're going to want to wind up in state court to begin with. And I actually have a case like that, where and jurisdiction-wise, I sued in the state where the defendant is subject to general jurisdiction. It's headquartered there, so that it kind of invokes Bristol-Myers Squibb a little bit. And the motion to dismiss fight was about injury in fact. And there was this big, robust, full-blown briefing and argument in court on injury in fact. And when defense counsel was done, I stood up and said, "That's a great argument, Judge, but it's better for that the courthouse down the street." Wrong courthouse. Illinois, where I was, doesn't have an injury in fact requirement in its state constitution. We needn't bother with that. Statutory damages are alive and well. We deserve to be here. And she said, "Yes, you do." So usually we'll be in federal court because of CAFA, but if it's a statutory damages claim, those BIPA claims, the biometric claims in Illinois, that's a really hot area. Those are all being filed in state court in Chicago and downstate. So the statutory damages claims are still going to be in state court. In terms of what state, well, you're subject to jurisdictional constructs, and you've got to pay mind to where general jurisdiction exists, maybe specific jurisdiction over your class representative. It needn't exist over your class members. That is Bristol-Myers Squibb. I actually channeled through the Musat case out of the Seventh Circuit, where jurisdictional requirements don't apply to class members, only the class representative. And I didn't want to get into text, but I guess I just did. I just taught it on Monday, so it's still in my mind. I'll forget it by next Monday. So in terms of what state, if you can pull it off, California. That's where Bristol-Myers sued. And one of the questions I asked my students, I said, why do you think the non-Californians filed in California? I don't know. Why? Because everyone wants to be in California. I mean, they love it. The laws are great. The judges are great. It's all that. It's a straightforward, simple analysis. Sue in California if you can get away with it, right? And they couldn't get away with it. They all got bounced, except for the Californians. So you've got to be thoughtful and mindful and textually sincere insofar as your jurisdictional choices, not just pull the trigger and sue in California or sue somewhere that you think is good, because that's not good. That's not smart, and it's not honest. It's not right.
That was a great distillation of how to choose your case and where to file it. So yeah, I'm sure. Do you have you come at this from a particular company, so I imagine where are people trying to sue? Is it California? Like I would imagine it is.
Well, from California, I say it's where the plaintiffs want to bring it, right? That there's this strategy and it's being taught in classes. It's pretty obvious a lot of times. And I think what's interesting, sometimes the class actions go viral. I don't always understand because you'll see one filed in the federal court in a certain state, and then you'll see some copycat state actions filed in various places, and then you might even find another federal one filed in another district, and there'll be consolidation, they'll move around. But it's interesting to see sometimes different plaintiffs' attorneys coming up with different ideas of what's going to maximize recovery. Maybe they're just better in jurisdiction, or that's where they have an office, or the named plaintiffs, or maybe they just have an idea that there's a particular statute that's going to be better, and you'll see the jockeying among the plaintiffs' attorneys when they're trying to convince each other, and I'll sometimes see like an amended complaint where they've now, all the plaintiffs' attorneys have jumped onto one complaint, and they've joined their named plaintiffs, and they'll agree to dismiss a case in one jurisdiction, and they'll bring those claims. In my case, it was they dismissed some of the Midwestern class actions and brought them in California. So the California lawyer said, whoa, what are you doing? You're bringing a case over there. Yeah, you got great juries in St. Louis, but your class action, you're going to get better rulings here in California, and they brought it into California. And it's hard as an in-house lawyer because you don't want to be dealing with 6, 7, 8 different class actions. That's a strain of itself. So you'd rather just have it in California, even if the plaintiffs think it's more favorable, and at least have one class action, maybe one lead lawyer you're dealing with, consolidated discovery. So there's some advantages, but that's the beautiful system we have with 50 different states that you're sometimes subject to.
Funny observation, in Bristol-Myers Squibb, what Justice Sotomayor recognized, or thought she recognized in her dissent, was the problem of having to file in multiple states for plaintiffs' lawyers. And it's like, oh, that's great for plaintiffs' lawyers. They want to cause you fits because you have to hire 7 defense firms, to defend 7 cases, there's no consolidation, and you're going crazy, and we're deft and nimble and alacritous enough to be able to staff all these different states, because we have lawyers in the different states where these cases were sued, because the folks suing them necessarily were there. But at the same time, if we're in federal court, I mean, often things are going to be subject to MDL and will be lumped together and sent somewhere. Because if you have state law claims, there's really the notion of suing a single, a substantive claim under, the notion of suing a claim under a single state's substantive law has largely gone by the wayside. You could take refuge in Schutz if you wanted and suggest that, hey, listen, if there's no conflict, or if the laws are the same, or if there's due process, in place, we can sue under one state's law. I haven't seen that fly in 10 years. So we're going to have to sue, we're going to have to populate various states. And you know what states they are, don't you? Do you know what states they are, you guys? Take a guess. You know the big one. California. Where? No. The states that matter.
Oh.
New York, Texas, Florida, Massachusetts, Illinois, Ohio, and Michigan, and PA. Where you have like a de facto nationwide class, after having sued 6, 7 states. MDL those, the thinking is you'll have critical mass to generate a class settlement at the right time. And then you got to get into ensuring that you're not overreaching and settling out states where you don't have class representatives, because that's what plagued a case of mine that lasted 13 years because lead counsel screwed up and started settling states where he didn't have class reps, and we were caught up in 2 Ninth Circuit appeals, and the Supreme Court just denied cert 2 months ago. So there's a lot of thought and calculation that goes into where and why and how, and on whose behalf to sue these states. And that doesn't even get into leadership. Who's going to run this mess when the dust settles? When MDL's over, then the real fun starts, because you're talking about who's going to run this stuff. And the judges are like, that's your all's problem. Please don't let me have to decide leadership. But sometimes they do. And it's a whole sideshow that y'all just Chris sits in the sidelines and just makes money watching this thing devolve into chaos. And that's the best way to make money, watching the train wreck. But
I'm not sure that it is.
We see some of this when finally the case gets to a point where now I want to go depose those named plaintiffs. And some mine are going to be auto cases, so I want to see your car. I want to bring it into a dealership. I want to inspect it and see this problem. I have a case, for example, where people are complaining about their Apple iPhone after an update not working quite right with their car. And the issue is the person on the other side of the call, if your volume isn't adjusted the right way, could hear an echo. And it was an update that Apple made years after I'd sold you this car that changed the volume setting, and now you got to change the volume on your phone. Well, they're suing the car manufacturer, not Apple. And okay, I'll bring in your car. I want to see if it actually displays that. And I want to depose you. Do you even use an Apple phone? And what's funny is now we're a year or 2 into the case, and we're finally going and say, okay, bring your named plaintiff's car in. Oh, they don't have that car. They sold it. Why in the case? Or that person died. Or that person has an Android phone. Or that person replaced that part of the car a long time ago. The plaintiff's attorneys don't even know that. They're embarrassed. They drop those folks once that comes to their attention. They're telling me, sorry, he won't be showing up for a deposition. He's not going to be named plaintiff. But you know what? There's another, we're going to replace him with another one because we need somebody from that state. So somebody comes up and takes their place. So it's kind of whack-a-mole for us. But I get to see some of this maneuvering much later on in the case when I'm now wanting to talk to those plaintiffs.
But none of this should be a secret to plaintiff's counsel. I mean, class reps should be meticulously considered on the front end. I mean, in my price-fixing cases, for instance, we'll often send a 7, 8, 9, 10-page questionnaire to ensure standing and suitability and adequacy and all the stuff that makes for a good case, because they're doing a job not just for themselves, but for everybody else. And when it comes to Basheer's and Chris's deposition of these folks, class rep deps can be scary because I tell my clients, you don't have to score any points. You're like a goalie at a class rep dep. All you got to do is keep them from scoring. You're not going to prove your liability theory through anything we're not going to prove it through anything you say. Just, hold up well and, demonstrate adequacy, because you are adequate, damn it. I mean, we made sure of that, and you're a good person. We had a litigation hold, and we kept all your stuff, kept your car, kept your phone. But often, I heard a story where somebody showed up at a deposition and involved, I forget what, and defense counsel asked the client why he thought he was there, and the guy said, I don't know, I just was told to show up today. Well, did you buy, it was like a securities case, did you buy thus and such issue? Like, I don't think so. You know, when did you meet your counsel? Outside? I mean, that's not okay. They're funny stories, but, you know, doesn't make it okay. I don't like telling them, I like telling how to avoid them.
All right. Questions? Don't be shy. We got a question back here.
Were all
think-
your cases in California?
Microphone.
I have one in Florida, actually. But,
Oh, do you?
The rest are in
Oh,
California.
yeah, go figure, right?
Yeah, Florida would, so that would have been on my list, Florida.
So maybe you can help me understand the difference between the class actions versus the multi-district litigation, because in
Are
state.
you looking at
court-
me? You look like you're looking at
kind of
I'm not
looking at all of
Professor,
us.
you teach a class.
Because in state court, I'm seeing a lot of multi-district litigation cases that I get. For instance, I had about 100 Apple cases where I think they forced you to download a particular program that slowed your phone down. So I had 100 plaintiffs that sued. Are these people that are not a part of the class action that have elected to not become a part? And so
Yeah.
what happens is that I'm in Alabama,
Okay.
but they send a lawyer from California that, you know, files a bunch of motions and asks me to just hold off on this until the multi-district litigation in California
I see your
is
point.
complete.
Okay.
So is this a class act? What is this?
Okay, sure. Oh, and I'm good friends with Greg Cook, by the way.
Oh,
Yeah,
yeah.
yeah.
Okay, yeah. They're neighbors of mine.
Oh, really?
Yeah.
Oh, I'm going to see him in a few, what's your name?
Sheree Grant.
Okay, I'm going to see him in a
Yeah.
few weeks, okay. Well, often you have parallel federal and state cases, right? Let's say, for instance, there's no diversity in Alabama because it's an Alabama defendant, maybe? Is that right?
Maybe so.
Okay, Alabama class?
I think it's an Alabama class.
Okay, yeah.
Yeah.
Yeah, and there's no CAFA jurisdiction, so they can't kick it to federal court. So there's a federal MDL going on, but you're the state backstop, so to speak. So they want to put you on ice until the federal case, right? Yeah, it gets cooking, and see how that goes. And if the federal case kind of goes down the tubes, they'll try to crank yours back up to see if they can't do something out of Alabama, like maybe a nationwide settlement if it's an Alabama defendant, because of the whole, there's a choice of law issue, of course, not to confuse that with nationwide jurisdiction, right, over absent class members. So can Alabama law apply nationwide? Under Schutz, maybe, because there are no due process issues, arguably. You know, there's a lot of action and traction in play between state and federal, but it's usually the state cases that they want to put on hold pending the outcome of the federal one.
Yeah.
Does that sound familiar?
Yeah, definitely. And what it does, it backs up our case law.
Oh, yeah.
For years.
Oh, sure.
So I just don't know what I should do about
And it just sits there, right?
it. Exactly.
And do you get like dirty looks when the chief judge says, "What's this case doing sitting there?"
Yeah.
Yeah.
Absolutely.
Yeah. Well, you could always, restart it. Say, listen, just because y'all got a federal case going doesn't mean I'm gonna, be your lapdog and sit around doing nothing. We're gonna move this case. If you don't like it, dismiss it. Right?
Every 2 or 3 years, I'll get a letter from a law firm I've never heard of inviting me to join a class. These dates are totally made up, but for example, in 2015, I would get a letter asking if I'd ever gotten telemarketing phone calls offering me a free cruise between 2009 and 2011.
TCPA letters.
I will have no memory whatsoever, except that I used to get that sort of phone call, and I never took a free cruise, and I never went to the timeshare to view it. But I remember getting those phone calls, and it will invite me to be a member of a class because of some deceptive
Is
practice.
that a notice or a solicitation letter?
I have no memory of that. I don't know. I am a lawyer, but I'm a total consumer. I don't pay that much attention. So I'll sign the postcard, send it in, and then 3 or 4 years later, I'll get a check for $61 and tell me it's from the law firm of whoever in Cleveland successfully prosecuted this deceptive practice. And I'm a no-injury claimant. So but yet, if they were deceptive, and I don't like telemarketing calls in general, and I don't like timeshares, and I don't want a free cruise, so internally, I will be a little bit glad that I had a part in punishing these people for deceptive practices. So my question to you all is, and this is, I guess, on the higher level, is there a benefit to the no-injury claim because it does enforce some sort of punishment on those who are deceptive or who knowingly market defective products. If I had worked for an hour and a half and only got paid for an hour, I'd certainly remember it. If I'd been injured by a defective medical device, I certainly remember it. But I don't have any memory of who it was who called or when it was. It's just that vague and that hard to be a member of the class.
I want you, you're better off with this one, but that's a statutory damages claim. That's a TCPA claim. So it's not really no injury. But conceptually, we understand your question.
Yeah, I mean, I would say that Telephone Consumer Protection Act needs to be reformed anyway, so it is a form of no injury. But yeah, I mean, in a variant of that doesn't involve the Telephone Consumer Protection Act, where you have, you explained no injury perfectly. Like, there are other, I view that as, that's a case that should not be a class action. There are other avenues to punish the wrongdoer if you've been deceived, or not you personally, but if someone has been deceived, there are other vehicles for that. You have regulatory, you have some sort of regulator probably is in that space. You have individual claims if someone actually was deceived and they went and bought a timeshare or whatever, and the timeshare went belly up or was whatever, yes, they have actual damages, they have a claim, and they can recover. Should every person who received a telemarketing call for a 2-year period recover? I would argue no. That's something that in that particular instance, that's something a regulator should get involved with, and at some other level, Congress should get involved in and say, you know, if we really want to create something, that we can figure that out.
And the way I think of it is the default under the tort law or procedure should be that if there's no injury, we shouldn't be wasting the litigant's time with it. But then if the legislator goes, this is a kind of problem where if we don't put some kind of penalty, we want to disincentivize this, or it's going to go crazy. We're just going to get our phones lit up, and they may pass a law with statutory damages. That might be, it should be on a case-by-case basis with legislators coming in and saying, let's take care of it, rather than us diluting tort law and this idea of having an injury just to capture those cases. Because that's the problem I have with these automotive cases where it's so odd because I can't even identify what my injury is. I'm the named plaintiff, and I got to wait for an expert to come up and tell me how much I overpaid on the car. And the way they do it is these very unscientific surveys sometimes. If you had known that your car had blah, 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 would you have paid the same? Oh, probably not. How much do you think you would have paid for this feature? And they put a number down, they average it, and they tell you, oh, well, you were damaged by $10 on this purchase when you got the push button start. So to me, at that point, I kind of know if I'm being inundated with solicitations on my phone. I mean, I've got to the point where I have 2 or 3 robo-blocking devices on my phone. I am being annoyed. I'm glad that the legislature or FTC will pass some kind of statute or regulation to stop that. But I don't want to then twist all of class action law to protect me from that, because I think there's a lot of other horribles that will come out of that.
Don't look at me. I mean,
I've already hired you for this. right?
yeah, my work here is done. Yeah, well, I don't know. Statutory damages cases are tough for me to get my mind around. I think at some base level, it's just a function of how you were brought up. You know, some refer to that as the gastronomic school of jurisprudence. It kind of depends on what you had for breakfast. You know, like I feel this way or I feel that way. I mean, I can understand merit in both sides. Nothing really happens, so no harm, no foul. But you know what? Congress wants folks to stop, and that's the remedy that they enlisted for that sort of indiscretion. There's a lot of push-pull there. It's obviously coming down in favor of kind of the defense perspective, obviously following Spokio and Ramirez. But is it completely there yet? No. Thomas said as much in his footnotes. Sue him in state court. So get ready.
Yes, sir.
I have a couple cases, forgive me for not going to the microphone. I have a couple cases about higher education institutions that charge full freight through COVID and Zoom. Has anybody followed how those are shaking out or heard of that?
Have you? Go ahead. Have you?
What's that?
Have you?
No, I mean, I've read about them, but probably no more than your average reader of these types of cases. Have you been following?
Modestly,
Oh.
yeah, I was approached with a few. I think they're terrible class cases. Because, you know, just because nothing promised you in, you know, live classes, a live classroom experience. For some people, actually, being at home is easier, better, safer, more enjoyable. Maybe they're far from class. Maybe they are caring for somebody. Maybe they have a disability. Maybe this is a welcome change from having to be in class all the time. What captivates me isn't so much the missed classes as it is the other fees. For instance, the health service fee for the health center that's closed, the athletic fee for the teams that aren't playing. I mean, there's absolute objectivity as it concerns that. There ain't no football team on the field, right? The Buckeyes are not playing, period, end of story. Can I get my money back for tickets? I know those cases are in suit. I was invited into the Michigan and Ohio State cases, but they were so heavily populated, I'm like, there's no role here for me, because everybody jumped on those. There's a firm in Boston, Pierce Atwood, that maintains a list of the higher education cases, and if you want the name of the person there who's got all the data on that, I can give it to you. He's a friend of mine.
Right. Yes, sir.
Thank you very much. I know we have a panel that's just going to be devoted to third-party litigation financing. However, it's a different group of panelists, and I'd just like to ask the ones here their observations on whether they think third-party litigation financing is affecting class action lawsuits. Thank you very much.
Generally speaking, connecting ... or affecting, okay.
I would
do
say
you
affecting everything,
What do you
but
think?
I think yes, but,
Favorably or unfavorably?
I mean, I would,
Ethically or unethically?
the ethical one's a harder
Who's
question
calling
for
the
me.
shots, right?
Favorably, I would go with, I generally come out against third-party litigation finance just because it
How
does
come?
change the dynamics of who's pulling the strings at the end of the day.
But all the deals, so far as I understand, I've never gotten funding, all the deals proscribe the funder from having any litigation authority.
Yeah, I mean, again, it's
Like
what...
an insurance company calling the shots in an auto case, which they do.
Yes, they do, yes.
But that's okay.
Well, I mean, it's a difference, well, there's a tripartite relationship between those two that are, because they are your policyholder, it's the company, as opposed to a completely random investor. I think that it does change it because, especially if you don't know that there's, if you're a defendant, for example, you don't know that there's an investor in the picture, you don't necessarily know who you're dealing with. Yes, I'm sure all the agreements say control rests with the plaintiff. I'm sure that, but in practice, I'm not so sure that that's actually what happens.
Okay. I've dealt with folks, I mean, I know folks who get litigation funding because it's rampant. These funders are throwing money at plaintiffs' firms. And so far as I understand, and I can't attest to this because I've not gotten into this with anybody, it's never affected anybody's litigation decision. And I don't know how it would, other than, settling short to pay these folks back. I mean, that's not what business plaintiffs' lawyers are in. So we talk about affecting the litigation calculus. In what manner, how, when, to what extent? I'm not even sure what that conclusion derives from or how it's implemented. It's just more of a conclusion to me that's unfounded on top of it all because I've never seen it happen.
I think it's affecting in terms of it's bringing litigation. And I did plaintiff's work, I've done defense work before going in-house, and I was getting inundated with those calls much more recently, I'd say in the last 5 years than before. And I know partners, I mean, this is not just a plaintiffs at your own shop, it's even at big firms. I know of an entire practice at big firms that they basically go get third-party funding and they do these presentations to these international firms, not even US-based. For example, international arbitration practices, increasingly, they go get funded before they file the arbitration. That lawsuit probably wouldn't be brought, because let's say you're representing a sovereign state, they don't have it in the budget, they don't want to allocate money from their budget to bring the case. So you, as an enterprising arbitration plaintiff's attorney, go to them and say, what if I could get it funded? Would you then bring the claim? Oh, well, yeah, but I don't have to pay for it. And then you go get the funding, and then you bring that case. And I think that's what can happen here domestically, too, is, the idea is, well, the plaintiff's attorneys are incentivized by a risk reward. They're not going to bring these frivolous cases because if they're smart, they're going to lose money. But now what if nobody has the risk? It's kind of like the idea of the insurance, where there's, where are you allocating the risk now? The plaintiff's attorney can bring it if they've convinced the funder to give the money. The idea is, well, the funders are sophisticated. They won't bet on the wrong horse. But I tell you, I was getting approached all the time. I think there's people out there just throwing money the same way people throw money into cryptocurrency. So I think the effect is we're probably seeing more cases that are being filed that might not have.
I wonder if that means I have to give back or cancel my line of credit. Isn't that conceptually the same thing?
Yeah, very similar, yeah.
I don't want to do that. I mean, do you guys want to cancel your line? Chris?
Well, I'm sorry.
I'll tell you, I was a plaintiff's attorney without a line of credit, and that's why I had to leave and
Right.
become a defense
It's
attorney.
scary, yeah.
'Cause I didn't think it through. I didn't make payroll for a while.
So I have a question. I hear we have 2 minutes left,
Wait.
and I'm at the microphone. How appropriate? He seems like a nice guy, but how do we get him out of the mix? And what I mean by that is, I'm a member of Lifetime, and I'm not going to pick on Lifetime. I've been a member for
I'm a
10
member too,
years. Yeah,
actually.
24/7
I signed up
is
in
what
the
I bought
trailer before they
into.
even built the place in Cleveland, yes.
24/7 healthcare, or the gym, right? I can go there 24 hours a
Not
day.
anymore, is it?
Not anymore.
Yeah, right.
Did your fee go down?
No.
No. So the point is, I don't have the time to deal with that. I don't have the time to go to Lifetime and argue and say, wow. But there are those situations. And the point is, I guess if everybody, maybe Toyota is the anomaly, maybe they do the right thing all the time, but isn't that the role of the class action where there's no claim? The quarter case or whatever, I don't know. How do you get away from class actions? Respectfully, they seem like a necessary evil. I mean, I think that's the premise of this discussion.
I think we're all in agreement that class actions serve a purpose in the right context. Like, there's no, I don't think any of us are disagreeing with that premise. It's when a class action, where do you draw the line? And we've traditionally drawn the line at an injury, an actual harm of something. So when the example was earlier when you didn't get your paid for the half hour you spent working at whatever job you did, and they told you in your contract that you would get paid for it. That's an actual harm you have suffered. Whereas,
But Lifetime's not going to they're not going to address that until he shows up.
But I saw it happen, I decided not to show, because I didn't care that much. I thought it was like obscenity, and
I don't know,
it
I'm
didn't qualify as
just,
obscenity.
maybe I'm
obscenity.
looking for utopia, right? Everybody just does the right thing all the time. Then that would put all of us out of work, but I digress.
Yeah, I think we do, that's the role. We want class actions. I think the problem is nobody's minding the store sometimes on the class action. Named plaintiff may not be injured, may not be motivated, so it maybe puts more stress on the court system, unfortunately, to weed those out and go, this is one that we need it because otherwise no individual action is going to address it. Whereas these ones, why are we dealing with it? If somebody's actually hurt by the car being stolen, they will bring a case for that. So why do we need a class action about the increased risk of the car being stolen? And unfortunately, it's going to come down on the courts
Well, it's
early on the
economics,
case.
Right? It's all economics.
Law and
Yeah,
economics.
I know. I'm an economics major. Thank you. Appreciate
You're
it.
welcome.
All right, I think our time has now expired. I want to thank the panelists, and let's give them another round of applause for their presentation. An interesting panel.